Imagine you walk into a supermarket in Addis Ababa and see a beautiful television on display with a price tag of 15,000 birr. You bring it to the counter, but the cashier says, "Sorry, that price was a mistake. The real price is 25,000 birr. Can you force the shop to sell it to you at 15,000? The answer lies in Article 1687 of the Ethiopian Civil Code. Let me read you the exact text of Article 1687, titled Declaration of Intention. It states, "No person shall be deemed to make an offer where a. He declares his intention to give, to do, or not to do something, but does not make his intention known to the beneficiary of the declaration, or b. He sends to another or posts up in a public place tariffs, price lists, or catalogs, or displays goods for sale to the public." Now let us break this down element by element so that everything becomes clear. The first key concept is the difference between an offer and a declaration of intention. This is one of the most important distinctions in Ethiopian contract law. An offer is a firm proposal that, once accepted by the other party, immediately creates a binding contract. A declaration of intention, on the other hand, is simply an indication that someone is willing to enter into negotiations or do business in general. It does not create a binding contract when someone responds to it. It is sometimes called, in comparative law, an invitation to treat. Why does this distinction matter? Because if something is only a declaration of intention, the person who made it is not bound. They are free to negotiate further, to refuse, or to change the terms. But if it is a real offer, the moment the other party accepts, a contract is formed and both sides must perform. Article 1687 gives us two situations where the law refuses to treat a communication as an offer. The first situation, in paragraph A, concerns declarations of intention that are not communicated to a specific beneficiary. If someone simply expresses an intention to give something, to do something, or not to do something, but does not direct that intention to a particular person who would benefit from it, the law says this is not an offer. For example, if you write in your private diary, "I intend to donate 10,000 birr to my cousin," this is not an offer. Your cousin cannot enforce it because you never communicated this intention to him. The second situation in paragraph B is more practical and more frequently tested in exams. It covers three specific commercial activities. First, sending tariffs to another person. Second, posting up price lists or catalogs in a public place. And third, displaying goods for sale to the public. None of these constitute an offer under Ethiopian law. They are merely declarations of intention, meaning invitations for the public to come and negotiate or make their own offers. This is very important. When a shop displays goods with price tags in its window, it is not offering to sell them. When a restaurant posts its menu with prices, it is not offering to serve every customer at those prices. When a wholesaler sends a catalog with prices, that catalog is not an offer. In all these cases, it is the customer who makes the offer when they say, "I want to buy this." The seller is then free to accept or reject. Now let us apply this to a concrete worked example. Almaz owns a clothing boutique in Bol. In her window, she displays a designer dress with a price tag reading 3,000 birr. Hannah sees the dress, walks in and says, "I want to buy this dress for 3,000 birr. However, Almaz realizes that her assistant made an error and the actual price should have been 8,000 birr. Almaz refuses to sell at 3,000 birr. Can Hannah sue Almaz to force the sale at 3,000 birr? Under Article 1687b, the answer is no. The display of goods for sale to the public is not an offer. It is merely a declaration of intention. Therefore, the real offer was made by Hannah when she said she wanted to buy the dress for 3,000 birr. Almaz, as the recipient of that offer, is free to accept or reject. Since Almaz rejected the offer, no contract was formed. Hannah has no legal basis to compel the sale. The same logic applies if a supermarket advertises tomatoes at a certain price per kilogram. Customers entering the shop are not accepting an offer. They are making one when they bring goods to the cashier. The cashier, on behalf of the supermarket, can accept or reject. Now here is your exam tip. Remember that Article 1687 must always be read together with Article 1688 on sale by auction and Article 1689 on public promise of a reward. Auction sales are also treated as declarations of intention, not offers. The contract is only formed when the auctioneer knocks down the item to the highest bidder. But public promises of reward are different. They are treated as effective offers that can be accepted by performance, even if the performer did not know about the promise. So memorize this hierarchy. Displays, price lists, catalogs, tariffs, and auctions equal declarations of intention. Reward promises equal binding offers. Examiners love to test this distinction with shop window scenarios or auction hypotheticals. Also remember the policy reason behind Article 1687. The law protects merchants from being forced into contracts they cannot fulfill, such as when stock runs out, prices change, or pricing errors occur. If displays were treated as offers, every shopkeeper would be legally bound to sell to every customer who walked in, which would be commercially impossible. Finally, do not confuse declaration of intention under Article 1687 with the general concept of intention to be bound in contract formation. They are different ideas. Article 1687 is about whether a particular communication qualifies as an offer at all. Thank you so much for watching. Whether you are a law student preparing for your contracts exam or simply a curious citizen who wants to understand Ethiopian law, we are glad you joined us. Please subscribe for more clear and practical explanations of Ethiopian law.